Good afternoon. I want to welcome everyone. I'm Congresswoman Terri Sewell. I proudly represent Alabama's 7th Congressional District. I'm also the ranking member on the Subcommittee on Elections, and on behalf of Joe Morelli, who's a ranking member of House Admin, and myself, we welcome all of you to this shadow hearing. As ranking member of the committee's Subcommittee on Elections, I'm proud to hold today's shadow hearing on the state of voting rights and elections in our country. As we begin, I want to acknowledge the moment that we are in. The Department of Justice, which should be protecting the right to vote for every eligible American, is instead attacking voting rights and civil rights organizations. I want to say that I stand with Southern Poverty Law Center. For decades, you have done tremendous work on countering hate and extremism and fighting for civil rights, and I want to say that I'm proud to work with you. Today's hearing kicks off what we hope to be a series of important convenings and discussions across this country led by the Southern Poverty Law Center to help us in the essential fact-finding and record-building needed for the John Robert Lewis Voting Rights Advancement Act. You know, it was only 61 years ago that foot soldiers in my hometown of Selma, Alabama, dared to march, dared to pray. Some lost their lives for the right of every American to vote. I guess I don't really need a microphone, do I? I'm honored today to represent the city of Selma, my hometown, but I'm also honored to know that I'm not in this foxhole alone. We have some great folks today who will provide testimony about the current state of voting rights and what we can do. It was the courageous foot soldiers that on that historic day of Bloody Sunday that kindled the consummation of our nation's most sacred promise: one person, one vote. Many of these marchers were horrifically beaten. Nothing satisfies or justifies the violence that they face, but their actions led to the enactment of the Voting Rights Act of 1965 and transformed our society. No longer could black people be denied access to the ballot box. Gone were the days of forcing literacy tests, of guessing the number of jelly beans in a jar. Gone were the days of paying a poll tax. Gone were the days of horrific beatings and lynchings meant to terrorize black people away from voting. Gone were the days of political disenfranchisement and Jim Crow. Within a single year after the passage of the VRA, the number of registered black voters soared across former Confederate states. In my hometown, or home state of Alabama, the number of registered black voters surged from 11% to 51% after the passage of the Voting Rights Act. Within 4 years, over 50% of eligible black voters throughout the South had registered to vote. The skyrocketing number of black voters led to a dramatic increase in black political representation. In a single year, the total number of black elected officials at all levels of government in former Confederate states more than doubled, from 72 to 150. The number of black elected officials nationwide increased more than tenfold. We saw the election of Shirley Chisholm, Barbara Jordan, Andrew Young, John Lewis. People who served in this illustrious body was largely made possible because of the VRA. The Voting Rights Act and its later reauthorization worked to keep away discriminatory barriers to voting, protecting U.S. citizens from every walk of life. It protects the rights of non-English speaking Americans, Indigenous Americans, and people of Latino, Asian, and Pacific Islander descent. The Voting Rights Act is a bedrock that guarantees our country can and should live up to its highest ideals of democracy, of justice for all. And make no mistake, this vast breadth of backgrounds makes our nation more vibrant, resilient, and stronger. For decades, the VRA was reauthorized with overwhelming bipartisan support. Since its initial passage, Republicans voted for the Voting Rights Act 5 times. Most recently in 2006, under the Republican president, George W. Bush, who, I might add, also showed up on the 50th anniversary of the Selma to Montgomery March with his wife Laura because he was proud that Republicans' support for the VRA. In 2013, I think all of us know the Supreme Court struck down some of VRA's most essential and crucial protections. And the pending Louisiana Calais case further threatens long-celebrated vital safeguards. Congress must act to update the Voting Rights Act. I am proud to lead that effort as the ranking member of this subcommittee and as the sponsor of the John R. Lewis Voting Rights Advancement Act. I came of age in the shadow of the voting rights and the civil rights movement. Selma was more than just my hometown. It was where ordinary Americans became foot soldiers in an extraordinary fight to ensure that the promise of this nation extends to all of its citizens. As this year marks the 250th anniversary of this great nation, voting rights face extraordinary attacks at every level of government. Our country embodies the peculiar paradox of being a young nation, but the world's oldest democracy, mature enough to remain the shining light of democracy across the world, and still adolescent enough where it is necessary to renew the promise of voting rights and full democracy for future generations. We can and must revive the Voting Rights Act. We must pass critical pro-democracy legislation like the Voting Rights Advancement Act, the Freedom to Vote Act, and the Native American Voting Rights Act. The work we undertake today and in the months ahead will ensure that we have a VRAA that meets the needs of voters and eliminates the barriers to the ballot box. I thank all of you for being here today. I want to also thank Ranking Member Morelli, who will be joining us shortly. And in light of Congressman Morelli not being here, I think we should proceed with our testimony. I'd like to introduce our panelists today. Todd Cox is Associate Director Counsel of the League Defense Fund. As one of two associate directors, Todd works in partnership with LDF's 8th President and Director Counsel Janae Nelson, Associate Director Counsel Samuel Spattle, and LDF's senior leadership team to set and execute the strategic direction of the organization's policy and external work. I also say that Todd is also a classmate of mine from college. John Yang is the president and executive director of the Asian American Advancing Justice, AAJC. At that organization, John leads the organization's efforts to fight for civil rights and empowering Asian Americans to create a more just America for all through public policy, advocacy, education, and litigation. Next, we have Andrea Centino. She is the regional counsel for MALDOF, the Mexican American Legal Defense and Education Fund. As regional counsel of MALDOF's Washington, D.C. office, she oversees the organization's legislative and regulatory work in Washington and litigation covering the United States Court of Appeals 4th and 11th Circuit. Next, we have Rebecca Carruthers, is the president and CEO of Fair Election Center, a national voting rights organization. She previously served as the vice president for 4.5 years and has extensive experience working on issues related to electoral campaigns. Next, we have Arthur Ago. He's the director of strategic litigation and advocacy for the Southern Poverty Law Center. I want to welcome all of you for being here today, and we'll start with testimony from Todd Cox.
Good afternoon. Ranking Member Sewell, thank you very much for this opportunity to speak with you all this afternoon. My name is Todd A. Cox, and I am the Associate Director Counsel for the Legal Defense Fund. Thank you for the opportunity to testify this afternoon regarding the opportunities to strengthen our elections in the United States and perhaps thereby improve voter confidence. The Legal Defense Fund was founded in 1940 under the leadership of Thurgood Marshall, who would later become the United States Supreme Court's first black justice. We are America's premier legal organization fighting for racial justice. Through litigation, advocacy, community organizing, and public education, LDF has sought structural changes to expand democracy, eliminate disparities, and achieve racial justice in a society that fulfills the promise of equality for all Americans. Since our founding, we have prioritized protecting the right of Black communities to vote, advancing the passage of the Federal Voting Rights Act of 1965, and litigating seminal cases interpreting its scope, and working in communities across the nation to protect and strengthen Black voters' ability to participate in the political process free of discrimination. From our historical work in Smith v. Allwright and Brown v. Board of Education to our modern cases before the Supreme Court today, our organization has consistently and firmly held the belief that the right to vote and the opportunity to access political power are critical to fulfilling the guarantee of full citizenship promised to Black people in the 14th Amendment of the United States Constitution. And as we move toward the 2026 midterm elections, we are not simply approaching another election cycle. We are approaching a reckoning with the health of our democracy and whether we are truly living up to the promise of equal participation for all, as Black voters are currently facing one of the most significant threats of discrimination and disenfranchisement since the Jim Crow era, shaped not only by restrictive policies, but also by an increasingly hostile legal landscape and evolving barriers on the ground. Despite this concerning escalation of discrimination, we must remember that American democracy has never been perfect. It is not until 1965, with the passage of the Voting Rights Act, that this country took a meaningful step toward becoming a multiracial democracy. That progress has been hard-fought and built on sacrifice. But we must reconcile with the reality of this progress is under strain. Across the country, we are encountering policies that restrict access to the ballot and disproportionately impact Black voters and other communities of color. Since 2013, following the drastic weakening of the Voting Rights Act in Shelby County versus Holder, more than 100 restrictive voting laws have been enacted across over 30 states. This wave of harmful legislation shows no signs of stopping. In 2025 alone, at least 16 states enacted 31 restrictive laws, with at least 486 restrictive bills considered in all but 3 of the 50 states. At the same time, the legal foundation of the Voting Rights Act itself is under attack. We are seeing the continued narrowing of legal precedents through cases like Bronovich versus Democratic National Committee, which made it more difficult to challenge discriminatory voting practices under federal law. And now, cases like Louisiana versus Calais, which LDF argued twice before the Supreme Court, threaten to further weaken the ability of Black voters to elect candidates of their choice, putting fair representation at risk across the country. In addition, courts are considering whether private individuals and civil rights organizations can continue to enforce Section 2 of the Voting Rights Act at all. If courts adopt a theory limiting enforcement to the Department of Justice, the Voting Rights Act will become significantly weaker in practice, particularly in jurisdictions where federal enforcement is inconsistent or entirely absent. Courts have also begun limiting coalition claims, further narrowing pathways for Black voters and communities of color to seek relief. Even in the halls of Congress, legislative proposals like the Save America Act would further restrict pathways to the ballot box by requiring documentary proof of citizenship to register to vote. In practice, this would effectively eliminate online and mail-in registration, methods that the vast majority of Americans rely on, as only 6% of voters currently register in person. These requirements would disrupt voter registration drives that have long expanded participation in historically marginalized communities. The list goes on, as this current administration is also seeking to restrict mail-in voting, increasing the threat of voter intimidation through expanded law enforcement practices of polling places, and pursuing mid-cycle redistricting efforts that dilute political power of Black and Hispanic voters. Taken together, these actions contribute to a system where access is uneven, protections are weakened, and trust is eroded. The changes are experienced in real time by Black voters through long wait lines, reduced access to registration opportunities, constantly displaced voting sites, confusion around eligibility requirements, and increased fear of harassment. Across the country, some states are perpetuating inequality, passing their own versions of the SAVE Act. Others are stepping in where federal protections have been weakened. 9 states have enacted state voting rights acts, with over 10 others considering similar legislation to restore, expand protections against discrimination. We're also seeing the power of participation. In Fayette County, Tennessee, where no Black candidate could win election to the 19-member governing body because of unfair districts, the community came together to demand new maps that fairly reflected their voting strength. At the federal level, this moment demands renewed commitment to strengthening the Voting Rights Act, including, as you mentioned, the passage of the John R. Lewis Voting Rights Advancement Act, to restore preclearance protections and ensure discriminatory laws cannot take effect unchecked. Advocacy organizations must continue fighting back in courts as LDF and other organizations continue to file hundreds of lawsuits challenging discriminatory policies, many of which have successfully obtained temporary or permanent halt to discriminatory practices. Further, because political participation is inherently local, it is imperative to press for protections at the ground level. So as we confront this inflection point, we must realize that history has shown that progress is possible when Black people and other disenfranchised communities come together with purpose and determination. Like our brave predecessors who overcame the barriers of the past, we must meet the moment by fighting back with everything we have to protect the moment, to protect the right to vote in this moment. Thank you very much for the opportunity to present today.
Thank you, Mr. Cox. Mr. Yang.
Thank you very much. Good afternoon, Ranking Member Sewell. Thank you for inviting us to testify on this very important topic here today. My name is John C. Yang. I'm the President and Executive Director of Asian Americans Advancing Justice, AAJC. As a national civil rights organization, we maintain a permanent voting rights program that works to eliminate barriers specifically for Asian Americans and what they face in voting in our nation's political process, including defending and enforcing the Voting Rights Act, improving election systems, and providing an analysis of Asian American electoral participation. In addition to poll monitoring and voter protection efforts across the country, Advancing Justice AAJC, in partnership with APIA Vote, runs a multilingual Asian election protection hotline, 888-API-VOTE, which provides in-language assistance to voters. I appreciate this opportunity to testify on the importance of Asian American voting rights. The Asian American electorate is one of growth in numbers and relevance to the political community. Unfortunately, the Asian American community has yet to fully exercise its political power, in part due to barriers at the ballot box being erected precisely at the time because of our growing political power. Despite the growth of the Asian American electorate, which is the growing group of voters in the United States for the past 2 decades that has been growing at the fastest rate, participation rates still trail that of white voters by double digits in election after election. Asian Americans face multiple compounding barriers to voting, including discrimination, including anti-Asian sentiments, and issues such as documented proof of citizenship requirements, attacks on vote by mail, and language barriers to ballot access. As a majority immigrant community, Asian Americans can face significant barriers while trying to exercise their right to vote. Almost 1 in 3 Asian Americans have limited English proficiency, and the complexity of voting materials, which can present a challenge even for voters fluent in English, makes voting even more difficult. It should be remembered, however, that because English is your second language does not make you a second-class citizen. At the same time, onerous documentary proof of citizenship requirements disproportionately affects Asian Americans, which have the highest rates of naturalization of any major racial or ethnic group. Asian Americans approximately 2/3 of Asian Americans are immigrants, which by definition means that they do not have a U.S. birth certificate. So requirements such as documentary proof of citizenship presents an undue obstacle to eligible voters of Asian descent and their political participation. Vote by mail opportunities have been particularly important for Asian American voters who use vote by mail at higher rates than other demographic groups. Unfortunately, vote by mail policies are under attack, with Asian Americans being disproportionately harmed due to our community's outsized reliance on this method of voting. The growth of the Asian American electorate is seen as a threat to the status quo. History has shown that the most determined efforts to restrict minority voting rights occur precisely where communities of color become numerous enough to influence election outcomes. Efforts to suppress and efforts to silence Asian American voters in all communities of color must be met with legislative action. Congress must restore, must modernize, and must strengthen our Voting Rights Act by passing the John R. Lewis Voting Rights Advancement Act. A fully restored and modernized Voting Rights Act is essential to ensuring Asian Americans and all voters who can participate fully and freely in our democracy. The John Lewis Voting Rights Advancement Act provides a legislative solution to Shelby County decision, which includes a substitute coverage formula for jurisdictions based on a history of discrimination and a mechanism that addresses the needs of emerging communities of color that face discrimination. And it reaffirms our private right of action under the VRA. Thank you again for this opportunity to testify. I look forward to your questions.
Ms. Centeno?
Thank you. Good afternoon, Ranking Member Sewell. And thank you to you and Ranking Member Morale for the invitation to appear before you today. My name is Andrea Centeno, and I am the Regional Counsel of MALDEF's Washington, D.C. office, where we spearhead MALDEF's federal policy work and litigation in the Southeast. For 58 years, MALDEF has worked to promote the civil rights of all Latinos living in the United States. Since its founding, MALDEF has focused on securing equal voting rights for Latinos and promoting increased civic engagement and participation within the Latino community as among its top priorities. MALDEF has litigated numerous cases under Section 2, Section 5, Section 203, and Section 208 of the Voting Rights Act, challenging at-large systems, discriminatory redistricting, ballot access barriers, undue voter registration restrictions, and failure to provide bilingual ballot materials. As the Latino population grows, our work in voting rights increases as well. Latinos are now almost 20% of the total U.S. population. They have been the nation's largest racial or ethnic minority group since 2003, and Latinos are a growing segment of the U.S. electorate. They accounted for roughly half of the increase in eligible voters in recent election cycles, including the period leading up to the 2024 presidential election. An estimated 1.4 million Latino citizens become newly eligible to vote each year. While the Latino voting strength continues to increase, there also continues to be impediments to Latinos' access to the ballot. Latinos consistently have the lowest voter participation rates among racial groups. For example, in the last presidential election, only 50.6% of Latino citizens voted compared to 70.5% of white citizens. These gaps are the product of long unaddressed socioeconomic disparities, new registration barriers, increased voter roll purges, new strict voter ID laws, increased barriers to accessing polling locations, and language access issues. And for those Latino voters who are able to cast their ballot, we've seen persistent efforts to dilute Latino political power in order to maintain the status quo for the political establishment. As a result of losing the preclearance protections of Section 5 of the Voting Rights Act following the Supreme Court's decision in Shelby County versus Holder, MALDEF's ability to respond to the growing attacks on the Latino electorate are all that much more difficult. Even still, MALDEF dedicates substantial resources and time to protecting the voting rights of the Latino community. For example, this work includes MALDEF's challenge to Texas's 2025 racial gerrymander. After we won a preliminary injunction in the district court, Texas appealed to the U.S. Supreme Court. The stay entered by the Supreme Court, which allows Texas to use its racially gerrymandered congressional map in the 2026 election, raises serious concerns that states will enact racially discriminatory maps and then get away with it by claiming after the fact that the gerrymander was political. Additionally, MALDEF challenged an Arizona law that singled out naturalized U.S. citizen voters for registration cancellation. We won, and the trial court blocked Arizona from purging voters within 90 days of a federal election and blocked county officials from submitting naturalized citizen voters to the SAVE database for checks simply based on a reason to believe that the voter is not a U.S. citizen. I also want to speak briefly on the persistence of barriers to voting for limited English proficient voters. Too many jurisdictions covered by the requirements of Section 203 of the Voting Rights Act to provide in-language voting materials for designated populations are still not providing voting materials or assistance. We need more robust enforcement of these language access protections and the requirements under federal law. And much of that has fallen largely to organizations like MALDEF to fill that need. For example, Malta currently has 2 petitions for certiorari pending in the Supreme Court related to restrictive state voting laws that conflict with the Voting Rights Act's guarantee that voters who are limited English proficient, disabled, or low literate can receive voting assistance from their person of choice. In order to address numerous barriers to voter registration and voting for the Latino community and others, Congress must pass the John R. Lewis Voting Rights Advancement Act. This legislation will provide voters, including those from the Latino community, with the necessary and effective tools to push back and prevent voter discrimination where it occurs. Malta urges Congress to use its power to address the long-standing and new barriers that voters of color face when trying to participate in our democracy. Thank you.
Thank you. Ms. Carruthers.
Good afternoon, Ranking Member Sewell. Thank you for holding this important hearing to discuss the landscape of voting rights. My name is Rebecca Carruthers, and I am the President and Chief Executive Officer of Fair Election Center, a national, nonpartisan 501c3 organization that defends, expands, and facilitates voting rights. Our program model integrates litigation, policy advocacy, and campus engagement to meet threats head-on and build a more inclusive democracy. Through our Voting Rights Project, we use litigation, advocacy, and the distribution of original research reports, issue briefs, and other informational resources to fight threats to voting rights and work to promote democracy. We work directly with state advocates and on-the-ground civic engagement groups to ensure our work is deeply connected to those most affected by it. Our voting rights team investigates under-the-radar violations of voting rights and have sued to enforce federal and state law requirements in novel ways. Our Campus Vote project works with college campuses, including community colleges and historically black colleges and universities. We work with administrators, faculty, students, and local election officials to reduce barriers to student voting. Our goal is to help campuses institutionalize reforms that empower students with the information they need to register and vote and embark upon a lifetime of civic engagement. We are fighting to preserve democracy by protecting and expanding the right of all eligible Americans, regardless of race, age, income, or ability, to participate in our nation's elections without burdensome barriers to voting and registration. Students and other new voters in particular already face unique and systemic barriers to registration and voting due to limited access, opportunities, and infrastructure. Currently, multiple states are further manipulating voting rules to take power away from young people. This includes adding documentary proof of citizenship requirements for voter registration, a policy that disproportionately affects young people, while gutting methods they often rely on for access, such as online voter registration and community voter registration drives. Arizona's documentary proof of citizenship law impacts geographically, concentrated in areas that include college campuses, most of them likely young voters. 18 to 24-year-olds in the state were nearly 3 times more likely to be excluded from voting in Arizona's state elections because they lacked proof of citizenship. The same false conspiracy theories underlying the Federal SAVE Act, a number of states have followed the president's direction and have recently passed documentary proof of citizenship laws to register to vote. Those states include Florida, Mississippi, New Hampshire, South Dakota, Utah, and Wyoming in just the last 2 years. These laws have a disproportionate effect on students and other young people. State legislators are also attacking youth voting by removing student ID from the list of acceptable voter ID where such ID is required. That's true even though only 60% of 18-year-olds have a driver's license nationally, and despite the fact that student IDs are trusted to allow secure access to housing and financial transactions on campus. New Hampshire, Indiana, and Florida have all passed laws prohibiting use of student ID to vote just this year. Students are currently unable to vote with their student IDs in Indiana after being allowed to do so without issue for decades. Anti-voter politicians also have a long history of attacking polling places on campus. By forcing students to vote off campus, students are treated differently from other voters who have polling sites within their communities. In particular, in North Carolina, there are already counties that excluded campus voting sites during the primary election, such as Western Carolina University and North Carolina A&T State University. We have also experienced repeated problems in states such as Texas and Florida, where election officials have attempted to eliminate polling location sites. Students also face disinformation campaigns targeting them, along with other informational barriers. We have observed students being falsely told they are required to vote where their family lives rather than their campus community, even though students have the legal right to register and vote at the place they consider to be their current home, just as other voters do. When voter registration deadlines fall close to the beginning of the academic year, fewer students participate than when students have the opportunity to register and vote up and through, including on Election Day. Finally, even once registered to vote, young people also experience voter purges that disproportionately take voting rights away from new citizens. Fair Election Center has been focused significant attention this year on unreliable citizenship checks, and we know that many young derived citizens are vulnerable to inaccurate results from citizenship checks facilitated by DHS's SAVE program. SAVE, which was overhauled by this administration beginning last year, has an outsized impact on derived citizens because when they turn 18 and register to vote, DHS has no record of their status change unless they have filed paperwork with DHS specifically. Those papers aren't required, and they cost more than $1,300, and it takes months to process. We could talk about solutions. We must defeat legislation like the SAVE Act. We must pass a Youth Voting Rights Act. We must set a minimum federal standard to allow voter registration up to and including on Election Day, known as same-day registration. We must pass the John Lewis Voting Rights Advancement Act. We should make it easier for young people to vote, not harder. After all, the future health of our democracy depends on the constant growth and renewal of civically engaged citizens. Thank you, and I look forward to answering any questions you may have.
For the record, we've been joined by the ranking member of the Committee on House Administration, Joe Morelli from New York, who will give his opening remarks after we hear from the Southern Poverty Law Center.
Thank you. Ranking Members Sewell and Morelli, and members of the committee, thank you for the opportunity to testify before you today. I am Arthur Ago, Director of Strategic Litigation and Advocacy at the Southern Poverty Law Center. And as you know, SPLC is headquartered in Montgomery, Alabama. So let me just add, it's a particular pleasure to appear before an Alabamian today. No offense, Congressman Sewell. Congressman Morales. SPLC was founded in 1971 to ensure the promise of the civil rights movement became a reality for all. Today, we advance racial equity and justice through litigation, policy advocacy, community organizing, outreach, and shaping narratives across the Deep South and in Washington, D.C. One of our central tenets is that as we transform the South, we transform the nation. This country is teetering on the brink of ending our 250-year democratic experiment through authoritarian anti-voter practices. We have seen an unprecedented federal interference with elections with FBI raids in places like Georgia and DOJ demands for sensitive voter data across the country. We also have grave concerns about ICE targeting communities of color during voting periods, along with voter intimidation by vigilantes like we saw in Florida, Georgia, and elsewhere in 2024. While the most extraordinary threats to the upcoming midterms are largely new, we cannot lose sight of the years-long assault on the fundamental right to vote. From the gutting of the Voting Rights Act in the Supreme Court's Shelby County versus Holder decision to the passage of more than 100 state laws restricting access to the ballot, the past 2 decades have seen a steady effort to dismantle the very policies designed to create a more inclusive and representative democracy. States in the Deep South have led the way with pervasive restrictions at every stage of the voting process. These all take direct aim at the political power of Black, Latinx, Asian American, Native American, and other voters of color, among other marginalized groups. And I will briefly discuss 5 of these attacks. First, documentary proof of citizenship, also known as the Show Your Papers law. It's a prime feature of the Save America Act. And though it failed to pass at the federal level so far, copycat versions have gained momentum across our states. Last year, SPLC and partners challenged Louisiana's new proof of citizenship requirement in court. Mississippi and Florida just followed suit and passed their own versions of Show Your Papers to vote. And the Mississippi law is set to go into effect very soon, July 1st. Second, there's been an uptick in challenges to voter eligibility in a coordinated effort to burden election boards and intimidate voters. For example, anti-voter activists in Georgia have capitalized on a restrictive law passed in 2021 to challenge the eligibility of over 100,000 voters. Georgia and Mississippi have also employed overly aggressive list maintenance policies based on faulty data, resulting in improper mass purges of voters off of their rolls. Third, states have gone to the extreme of criminalizing the ability to assist voters. In 2024, Alabama passed a law that severely restricts the ability of civic engagement groups to help voters apply for absentee ballots. This echoed laws in Florida and Georgia that criminalized other forms of voter assistance, like supporting voters in long lines with food and water. Though the most onerous provisions have been at least partially and or temporarily blocked in litigation brought by SPLC and its partners, this disturbing trend continues. Fourth, during the pandemic, voters in the Deep South and beyond took advantage of the opportunity to vote by mail, a practice that the president and his allies regularly attack, despite the fact that the president himself recently used it. Florida, Louisiana, Alabama, and Georgia joined the growing list of states that have restricted absentee voting by mail in recent years. And finally, we must address one of the most nefarious forms of voter suppression, gerrymandering. The 2021 redistricting cycle was the first without the full protections of the Voting Rights Act. Map drawers in the Deep South, states took full advantage, not just for state and congressional districts, but also those at the local level. For example, maps to elect school board members in Cobb County, Georgia, city council members in Louisiana and Florida, as well as judges in places like Mississippi, have diluted the voting power of communities of color. And in fact, today, as we speak, our team is arguing against that redistricting in the Louisiana Supreme Court case. A common tool that we and our partners have used to challenge such maps in court is Section 2 of the Voting Rights Act, which prohibits discriminatory voting practices. Now that key tool hangs in a balance as we await the Supreme Court's decision in Calais, a case out of Louisiana, which could make these already uphill voting rights battles that much harder. In conclusion, the attacks on voting in the Deep South, and particularly for people of color, are persistent, acute, and only intensifying. We urge you to restore and modernize the protection of the Voting Rights Act through tools such as the John R. Lewis Voting Rights Advancement Act, and to institute national reform standards for election administration so that all eligible voters can exercise their freedom to vote. Further, we urge you to consider what else Congress can do to finally and fully protect the voting rights of people of color in the South and across the country. And to that end, SPLC and several partners, including those who are here today, are hosting a series of voting rights community conversations in states throughout the South and across the country over the next few months. Our goal is to hear directly from impacted voters about their experiences so that leaders in Congress have the information and evidence that you need to bolster our existing solutions and design new ones that fully meet this moment. We are grateful for this hearing as a forum to begin those conversations and look forward to sharing our findings from the Voting Rights Community Conversation Series later this year. Thank you again, and I look forward to your questions.
I want to thank all of our witnesses, and I now recognize the Ranking Member Morelli for his opening remarks.
Good afternoon. I apologize for being a little tardy, but American Airlines apparently has no respect for my schedule. So, but I'm delighted to be here, and I want to thank, first of all, my good friend and colleague on the House Administration Committee, Terri Sewell, Ranking Member of the Subcommittee on Elections, a longtime steadfast champion of the John R. Lewis Voting Rights Advancement Act, for convening us and gathering us together in what could not be a more timely or important conversation. And always grateful, Arthur, to be with a daughter from Selma, the representative of America's Civil Rights District. Representative Sewell is a stalwart defender of voting rights in the halls of Congress and around this country. So before I continue, I want to say I proudly stand with the Southern Poverty Law Center. The president pardons violent extremists, people who tried to overthrow the peaceful transfer of power in January of 2021 while charging a civil rights organization that has spent decades taking on hate groups and standing up for voting rights. So it's unconscionable, it's un-American, and we're all going to do everything we can collectively to support your efforts. So thank you. And thank you to all the panelists for being here, not only for your comments today and participating, but what you're doing every single day. We appreciate that work. Access to the ballot box and the equitable access to it is critically important, so I'm grateful for the conversation here. You know, I think in my view, there's nothing more important in this moment than protecting American democracy and doing the work to make sure we are a government of the people, by the people, and for the people. And I know that not only does Representative Sewell share that firm belief with me, so is Hakeem Jeffries, who has charged us really to conduct conversations with folks and to make sure that we're doing everything we can to make sure the midterms come off. And in order for that to come off, it means that every eligible American has free, fair, and secure access to the ballot, regardless of their zip code, their race, their age, their physical ability, or the languages they speak at home. Obviously, we would all agree at every turn the Trump administration has sought to destroy our institutions, has tried desperately to build barriers to the ballot box to keep Americans from exercising their most important right, and particularly, as you've all identified, certain groups that he seeks to keep from the ballot box. Earlier this year, in the State of the Union address, President Trump referred to voting as a privilege, as he is often on in regard to this topic. He was sorely mistaken. Voting is a right. You know, a privilege is my 5-year-old grandson getting 5 more minutes of television before going to bed. A right is enshrined and cherished by all American citizens and is, you know, preservative of all other rights. I mean, nothing else that we have, all the rights guaranteed to us in our Constitution can't happen if people don't have the right to access the ballot box. And a right that Americans have marched for, have fought for, have died for, and a right that Congress needs to continue to protect because it is under attack, as you've all said. And over the last decade plus, the Supreme Court has tried to unwind the still necessary protections of the Voting Rights Act, something like, you know, our champion here to my left, to set back the progress we've made. It's almost hard to believe and to process that in 2026 we're having the same fights that they had during the civil rights era of the 50s and 60s, and thinking to have to revisit what Lyndon Johnson and the Congress did in 1965. We have never been a perfect union, but through centuries of struggle, countless Americans strive to make real our founders' promises of freedom and equality. And that's what the VRA is all about, making a more perfect union, and that remains our duty today. It always will be. The Trump administration has taken every opportunity to dismantle key institutions and the federal programs that work for the American people, including institutions, programs, and laws like the VRA. You know, I don't need to tell you because you already talked about the Save America Act, the MEGA Act, executive orders that are unconstitutional, illegal, immoral, and frankly unserious. And instead of sowing false doubt, and we talk about this often in the Standing Committee, perhaps it would be helpful if our committee was focused and the majority was focused on expanding opportunities for people to participate. You know, I am shocked still that in the 2024 presidential election, nearly 90 million Americans chose not to participate in the presidential election. It's astonishing. So shouldn't we be doing everything we can to remove barriers, to engage people in a process and build their faith in this institution that we call American democracy? So we're going to work on that. And if we're blessed to be in the majority, I'll knock on wood, that's what we're going to work on. And look, you know, I don't need to tell you again, 2 critical Supreme Court decisions, Watson and Kelly, both could add further burdens to voting rights and clearly contravene congressional intent, which is clear for the decades that these have been in place. So I could go on and on. I'm not going to because I want to hear from the witnesses, but I'll just close by saying I thank you all for the work that you're doing every day to push back on these assaults on our democracy and to defend voting rights laws. The American people deserve a strong and vibrant democracy after 250 years. It's astonishing that we're here. But again, I want to thank Terri Sewell for the extraordinary work and leadership she does and her friendship, and I look forward to hearing from all of you. So thanks so much. I yield back.
Thank you, Ranking Member Morelli. We'll now begin our questioning portion of the shadow hearing. I have a question for each of you, and I'm just going to ask that we limit the time for your response so that we get your response, but at the same time be cognizant of time. My first question is to you, John, Mr. Yang. The Trump administration has proven its intent to disrupt the 10-year census cycle. And I think that has horrible consequences for American governance, and was hoping that you could talk a little bit about why mid-cycle redistricting is not such a great thing and how it affects minority voters, specifically Asian Americans.
Sure. Thank you very much for that question. And you're absolutely right. The census provides so much useful data for all of our country, for the fundamentals of our democracy. But when it comes to voting rights, we should remember that the Census Clause in the Constitution is voting rights legislation. It guarantees that we get equivalent representation for each member of Congress. Right now, I believe under the 2020 census, each member of Congress approximately represents about 760,000 residents. And so if we have any sort of undercount or manipulation of the census, what that will result in is having members of Congress having disproportional number of residents that they are the constituents that they are trying to represent. And then the voting power of each of those individuals likewise would be affected. What we need is to make sure that the census continues to be an accurate source of information. Then when it comes to redistricting, you're absolutely right, Representative. What ends up happening is that if the census numbers are manipulated and undermined, then obviously that data will corrupt how we look at redistricting. And again, making sure at the end of the day that all of our communities are properly represented.
Very good. Ms. Carruthers, since the Shelby County decision, we've seen barriers to voting enacted across this nation, not just in southern states, but all across this nation. As organizations like yours work to encourage younger voters to engage in the democratic process, how do you see restrictive voting laws impacting their ability to vote and their desire to be engaged in this process, our young voters?
Thank you for that question. So restrictive voting laws increase barriers to voting. And so when you have young people, this is usually their first time voting, and now all of a sudden we're going to make it harder. A lot of times young people get a bad rap, and we are told that they're not interested, they're disengaged. But what we're seeing instead is that there isn't enough accurate information. And so when you have different states hell-bent and making it harder for young people to vote, even people close to this administration said that college students shouldn't be able to roll out of bed in their pajamas and go vote. And I say they should. We need students to be active participants in this democracy. And so to make it harder for them to vote, you're saying that their voice doesn't matter and their issues don't matter.
Absolutely. Todd, as we have heard today, many believe that the Supreme Court is likely to effectively gut Section 2 of the Voting Rights Act. I know it was painful for me to listen to oral arguments there on that day. I thought that the presentation of our General Counsel of LDF, Janae, was superb, but it looks as if they are hell-bent on gutting it. And for so long, the crisis for voting rights in America has been remedied by majority-minority districts. Can you talk about the profound impact of finding majority-minority districts to be against the Constitution's 14th Amendment and what that will do, not just for congressional redistricting, but for redistricting writ large?
Thank you, Ranking Member Sewell, for that question. Yes, we refer to the Voting Rights Act as our birth certificate for our multiracial democracy. And, historically, we've used the Voting Rights Act, and particularly Section 2, to effectuate the opportunities for Black and other communities of color to be able to elect candidates of choice. It's been critical. Particularly in the wake of attacks against Section 5 of the Voting Rights Act, the removal of the preclearance process, Section 2 was the tool we used to push back. And we've seen a lot of success. The case Allen versus Milligan, which was the predecessor to Calais, which in many ways the lower courts continue today to point to, upheld the constitutionality of Section 2 as a bulwark against removing opportunity for black voters and other voters of color to eliminate their opportunity to elect candidates of choice. So if the Supreme Court were to undermine that, it would effectually undermine the opportunity for us to protect voting rights using Section 2 as a tool. That said, we are prepared to do what we can to shore up opportunities for voters to elect candidates of choice, regardless of what happens in Calais. And one example I mentioned in my testimony was opportunities for states to pass their own voting rights acts, state voting rights acts, which not only shore up Section 2 in the traditional sense, but restore Section 5's pre-clearance process at the state level and allow states and local jurisdictions to tailor responses to attacks against voters in their own way.
Yes. The point about Section 2 is that it allows for race-neutral tools.
That's right.
And so in light of the fact that that the Supreme Court looks like it's going to narrow that, what, if any, meaningful way can we preserve majority-minority districts using race-neutral tools?
Well, I think that, we still have the 14th Amendment.
Yeah.
We still have intent. And long before Section 2 in its current form, we had the opportunity and we had to enforce minority voting rights using the intent clause of the 14th Amendment and using the intent strategies and laws we had in place. I think also we, as I said before, are pivoting to the states to pass their own versions of voting rights acts that we can use to litigate those kinds of attacks at the state level. I think that race-neutral or use of race to remedy race violations are still things that are at play and are certainly things we put on the table to in order to protect minority voting rights. We will continue to use those tools even after Calais.
Thank you. Andrea, Latinos make up close to 20% of the United States population, a proportion that is rapidly growing. And Latinos in the United States face specific threats to the right to vote. In fact, in 1975, expansion of the VRA was done in part to address specific challenges that Latinos faced. In the 21st century, what specific voting rights threats do Latinos face, and how can Congress help address those through federal voting rights legislation?
Thank you for that question. So some of the specific threats that Latino voters are facing today includes a lot of what you've heard today. So specifically, when we look at federal and state efforts to increase or to put into place more restrictive state voter ID legislation or the Federal SAVE Act and documentary proof of citizenship efforts, these have a really harmful effect on the Latino voter population, and they only serve to increase the Latino voter gap that we see. In addition to that, we still experience many challenges based on language access. So there is not enough robust enforcement of the language access provisions of the VRA, whether that's compliance and enforcement under Section 203 for those jurisdictions that are required to provide language ballot materials and language assistance to designated populations, designated language minority groups, or more robust enforcement of Section 208, which is what MALDEF has been doing. There are a significant number of our voters who need that assistance and need to have fair access to that assistance in order to effectuate their right to vote. And both of these things combined really present, I think, a challenging environment for Latino voters today. They send a signal that you have to look a certain way to be believed and recognized as what a citizen is supposed to look like, or there is one, perception of what it means to be a voter at the polling location. And it really creates, the rhetoric that we have been hearing creates a real risk of harassment, a risk of violence that our voters face or potentially will face in upcoming elections. And so, as you know, we have struggled with the loss of preclearance and the more difficult landscape, right, for enforcing the VRA and enforcing voting rights for all voters, including for Latino voters. We really believe that the John R. Lewis Voting Rights Advancement Act is a necessary, important piece of legislation that Congress must pass in order to address what I've talked about here today, what's in my testimony, and certainly the voting issues that our voters face across the country. And specifically, I'll just be really brief, the known practices coverage or the practice-based preclearance provisions within that piece of legislation are incredibly helpful in ensuring that our community, which is a growing community, but does not necessarily have the same historic record of discrimination in voting because of the timing of our growth, means that we will have a formula that will allow us to protect voting rights going into the future.
Very good. Arthur, last question. Because preclearance is now gone, we fully expect, unfortunately, that this Supreme Court may gut Section 2. I think that the burden of litigating discriminatory practices in voting really fall to organizations like all of you. And I was wondering, what does the lack of fulsome Voting Rights Act impact? How does that impact the litigation work that will go on for you and others at this table?
Thank you, Representative Sewell, for that question. It's an important question to answer. And as I said in my opening remarks, our team is down in Mississippi right now litigating the redistricting case with regards to the Mississippi Supreme Court. We are incredibly busy. That team is incredibly busy traveling around the South and monitoring what is happening with some of these state laws, these state bills that are meant to mimic what this administration wants to do, in addition to the fears about what's happening with regards to Section 2 and whether or not it goes the way of Section 5. And so our litigation docket is increased. In terms of the way that we approach this, we've been here before. With the ratification of the 14th Amendment in 1868 and the ratification of the 15th Amendment in 1870, our communities have faced these challenges before, and our communities have gotten through it. And the 1965 Voting Rights Act was momentous because it was meant to cure and prevent everything that happened between emancipation through 1965 and through Bloody Sunday in Selma. And so it is a setback, but our team is exploring creative ways on the litigation front to attack what is happening right now, including going to, as our friend Todd said, going straight to the 14th Amendment and looking at intent as the ability to attack improper race-based gerrymandering, looking at something like the line of cases under the one person, one vote doctrine, and making sure that everybody's vote is counted equally, right? And then looking at other sort of unexpected avenues to attack the restriction on voting rights, like the Americans with Disabilities Act, because a lot of these laws attack the ability of folks with disabilities to access the ballot. And so even though we've been here before, let me just add too, in addition to litigation, the Southern Poverty Law Center and the other departments have really picked up the pace, understanding the limitation of what litigation can do right now with the gutting of Section 2 and Section 5. And so we've got our policy team who's here today advocating in the halls of this building as well as in the state houses. We've got our state offices and our organizers trying to make sure that we get out the vote. And we've got our communications department producing things like voter guides and not nonpartisan voter guides along the lines of what does it take to register and what to expect on election day. And so even though this is a substantial, we're anticipating step back, like 1965, we will eventually cross that bridge.
Thank you. With that, I'll turn final questioning over to Ranking Member Morelli.
Thank you. I wanted to go back to something I'd like to ask all of you, perhaps to respond to this or give me some perspective to something you said, Mr. Cox, which is the idea of having state VRAs. And I know in New York we passed an amendment to the state constitution implementing the John R. Lewis Voting Rights Act at the state level. So I'm just interested in how you see that if Calais goes as people fear, and the court makes a distinction that this violates potentially the equal protection, oddly, the equal protection clause of the 14th Amendment, and suggests that that it's unconstitutional. How will then the various states do something that will be still constitutionally appropriate at the U.S. Constitution, even within their state laws? If you could, and I'm happy to hear comments from all others.
Sure. You know, I think what we're contemplating and what our policy folks who are sitting behind me contemplate is that under state constitutions, under their own versions of the 14th Amendment, under their own versions of their, the right to vote strictures, that they would create their own infrastructure within which you could pass voting rights laws that would protect rights along the same lines as federal governments.
But would that not, just so I understand it, would that not that wouldn't run up against the Supreme Court decision on the constitutionality of the law as it relates to the 14th Amendment? As it relates to
they would be creating their own infrastructure, separate from, let's say, for example, in Calais, that they were to declare Section 2 of the Voting Rights Act of using race for redistricting purposes unconstitutional. The state of New York or the state of Maryland could decide, for our state purposes, we are going to require jurisdictions to submit voting rights or voting plans or voting changes that we would evaluate based on our own constitutional principles regarding opportunities to elect candidates of choice under our own state laws. I think the other piece that states...
Would that also include race?
It could include race, yes. And I think that what we are arguing in Calais and what I think states at the state level, what folks would be arguing is that race as a construct to resolve a violation of a state law to protect voters from race discrimination would be illegal under state law. And we would litigate those cases under state law. The other thing I would like to put on the table, which I didn't mention before, was that there are sort of alternative ways of doing electoral processes outside of the formal redistricting processes, so-called proportional representation strictures. A state could decide to elect local candidates using those tools, so-called cumulative voting or ranked choice voting. We're just at the very beginning looking into those kinds of alternatives, but I think everything has to be on the table if we're going to protect ourselves from what might come not only in Calais, but all kinds of attacks that are occurring at the federal level and at the state level. And the last thing I'll say is that, as was mentioned here, voters themselves play a role, making sure they're educated about their voting rights. We have a Black Voters on the Rise process where we're not only doing election protection on Election Day, but making sure voters are aware of the issues that are important to them so they know that they can use democracy to work for them. So that despite whatever restrictions are put in place, they overcome those by just turning out and making sure they're casting their ballots.
Does anybody have anything to add on that, on the question of Calais? Well, then let me just, Mr. Yang, the Asian American population in the United States is growing, and sadly facing greater anti-Asian sentiment in some quarters. Can you speak a little bit more about the growth of the population and how Congress and the Voting Rights Advancement Act can expand access for AAPI voters?
Absolutely. Thank you for that question. In terms of the growth of the Asian American community, just in sheer numbers, between 2000 to the 2000 census to the 2020 census, we've grown from over 10 million in the 2000 census to over 20 million in the 2020 census. So that represents an approximate growth of over 35% in both of those two censuses, which that means that we are the fastest growing community percentage-wise in the United States. Now, how that translates with respect to voting power is that on one hand, Asian Americans are starting to show up at the polls. Certainly, voter participation rates have increased significantly in these last 20 years. But as we have seen, we are still trailing white voters by double digits in election after election. Why does that happen? I would say that there's three things, and there's three things that voting rights legislation can seek to address. Number one is with respect to language access, as Ms. Zatino has testified about as well, is Asian Americans, a good portion of our community, 1 in 4 in our community, speak a different language at home. And so when we're talking about ballots and making sure that there's ballot access, making sure there's assisters of your choice at the ballot box. So that's Section 203 and Section 208 of the Voting Rights Act. That would be important. Number two is availability of mail-in ballots. About 46% of our population voted by mail in the 2024 elections. Over 2/3 of our population voted either absentee or by mail in the 2022 elections. So making sure that those vehicles are available. And again, there's a common sense to that. If you have a language issue, then having a little bit of extra time to be able to study the ballots at home, understand them a little bit, translate them for yourselves without the pressure of the ballot box would be important. And then number three is what we've already talked about in terms of some of these different voter intimidation tactics or the documentation issues. Again, if you're talking about having birth certificates that match Social Security numbers, that match other documents, I will admit, I will just be very personal about this. My naturalization certificate to become an American citizen has a different name, sort of, kind of, than my passport. So if someone really wanted to challenge that, they could say, well, these don't match, and therefore you can't vote. And as someone that has actually had the fortune of serving in our government, as well as in the private sector, as well as in nonprofit, that idea offends me greatly.
If I could, Ms. Centeno, you talked about polling harassment for Latinos, and I know that there are many Latinos throughout the country who are hesitant to go to church services, hesitant to go to work, hesitant to take their children to schools. We're struggling with this question of harassment at the polls. Any advice on what you think we ought to be doing in this moment to be to really help mitigate that? Obviously, we can respond in the courts on Election Day, but I'm afraid of all the people that get turned out before then. So in terms of mitigation, things that we should be paying particular attention to.
Certainly. I can say, for MALDEF, we have been leaning into the public education component of our work this year. Every year before an election, we obviously do robust public education about people's voting rights, what to know before Election Day, how you can cast your ballot, what you might need to have if you're going to cast it, in the different ways that you will cast your ballot, whether that's by mail, showing up for early voting, showing up for same day. All of that's incredibly important, but particularly at a time where people are uncertain about what their experience is going to be, however it is that they choose to appropriately cast their ballot for themselves. The only way, really, that we can make sure that our voters are doing everything within their power to be able to get that ballot into the ballot box is to lean into robust public education, making sure that voters know that if you don't want to go to the polling location on Election Day to vote, do you have other options within your state to send your vote by mail? What are the requirements for that, and do you meet them? How early in advance do you need to be able to submit for your mail ballot application? If you were going to go early, to go vote early, can you take individuals with you if you need language assistance? What are the laws? You are protected, and making sure everybody understands the federal protections that apply to voters, particularly to voters who require language assistance. And this is why our work in enforcing Section 208 of the VRA has been so critical, because everybody who needs assistance because they are limited English proficient, whether they're a voter with disabilities or a low literate voter, has the option to take their assister of choice, as long as it's not your employer or union rep, to go with you to the poll site to cast your ballot, and making sure that people are really aware of what their rights are, what their options are, and that MALDEF and other organizations like MALDEF are here and present and ready to receive any calls about trouble voting at the polls.
If I might just ask one, and then I'd just be curious, anyone and all can comment. It's hard in this moment to think about the Department of Justice as a bulwark for democracy instead of, and it's really hard for me to wrap my head around where they are now. I'd just be curious, as you're having conversations inside your organizations and just with your broader communities, if how you're sort of processing this, and I'm happy for anybody to comment on it and how we need to address that. Yeah, Ms. Carruthers.
So what we're seeing now isn't normal. We have a voting rights section at the DOJ that's been gutted. That's the first thing. We also have a federal government that's actively hostile against the right to vote. And so I just want to say that again. We have a federal government that is actively hostile to the right to vote. The role of the federal government in voting up until this point has been to enforce voting. We're seeing a DOJ that is set to restrict voting. This is not normal. Many people will argue it's not constitutional. I think all of us will even argue that it's immoral. If the point in this country is if you're eligible to vote, you should be able to vote, and when you actually cast your ballot should count, that's not what this DOJ is aiming to do. This DOJ is looking to create a chilling effect, to make people scared to actually vote.
Did anyone else want to just add anything?
I can chime in. We've talked a lot about, 2013 decision in Shelby County and all the proliferation of restrictions that result at the state level. And historically, we have a DOJ that either internally with an administration or certainly as partners, the Civil Rights Division would partner with us in pushing back on that. And we have a DOJ that's actually been weaponized against us.
Yeah.
Seizing ballots in Fulton County, suing states for access to their voter rolls. And the way we think about it, we look at DOJ through the lens of what it was intended to do. It wasn't intended to sue jurisdictions or sue states or companies over antitrust. That should still be what it does. But its real purpose were to enforce the 13th, 14th, 15th Amendments. And what we have now is a DOJ turned on its head. And instead of helping us protect our voting rights, it is actually being used to undermine them. And so from a standpoint of what Congress can do, we would urge that you do oversight, you hold them accountable for what they're doing, which is not only at odds with its original purpose, but really at odds with the rights and what the citizens actually need in this country in terms of protecting their voting rights. I think also from a standpoint of our organizations, what we do is that we try to shine a light on what's happening. Every case they withdraw, whether it's a voting rights case or an education case, we try to make folks aware of it. And we try to document and make folks, certainly our constituents, understand that DOJ was once an agency that could be a partner, but now it's as an agency that we all need to be just aware of in terms of how it's being utilized by this administration.
I can add to that. I will echo what each of my colleagues has said. The sort of ironic silver lining about the gutting of the DOJ is that there are a lot of voting attorneys from the voting section of DOJ that now are in the private and nonprofit sector. And they are attacking, ironically, again, the federal government, a government that they represented until just a few months ago. And, sometimes it's funny because when a case pops up, there is kind of a race to litigate that case among all of these Department of Justice former voting lawyers to see who can attack it first. It's difficult, Congressman Morelli, you asked what can be done sort of proactively. It's a little bit difficult because I'm answering a sort of reactive question.
Yeah.
And that there are lawyers that are out there that are ready to bring cases. And we can set aside Section 2 and Section 5 for the time being. And there are other sections like 203 and 208 of the Voting Rights Act, as well as 11B, voter intimidation.
Yes.
And that there's going to be private enforcement of that. And that is unfortunately reactive. But as Todd said, that there is an opportunity to, number one, is sort of for Congress, rest assured that the work is being done, but also an opportunity to exercise oversight, and sort of the not only the power of the purse, but, once you've delivered the money, what's happening with that money. And so that's the opportunity for Congress.
I will say it feels to me like this Alice in Wonderland moment where up is down and in is out, and it's just so strange. And while I'm with the daughter of Selma, I'm a son of Rochester, where Susan B. Anthony lived and did her work, and where Frederick Douglass came to identify his home and published the North Star about a mile from my district office. So we're grateful for all the work you do and grateful for my partner and friend, and that I yield back.
Well, as we conclude today, I just want to say thank you to all of our witnesses and to the organizations that you represent. We do live in perilous times, and I think that we didn't get here by ourselves, and we won't get through it by ourselves, but together. And so this is just the first of a series of shadow hearings and events that the Southern Poverty Law Center throughout the rest of this year will be doing. And our hope is to gather this information and to publish something to build a record, if you will, that will help us in our efforts to pass the John Robert Lewis Voting Rights Advancement Act. Our foremothers and forefathers were strategists and tacticians. They just didn't happen upon Selma. They were strategists. And so I'd like to leave us all with the thought that John Lewis, who was riddled with cancer the last time he was on that bridge in 2019 for reenactment of Bloody Sunday, but his voice was very strong. And if you close your eyes, I think you could hear him say, "Never give up, never give in. Keep the faith and keep our eyes on the prize." That's what this committee plans to do, and we can only do it with your help. And with that, this hearing is adjourned.
Picture?
Yes. We'd like to take a picture with our wonderful witnesses.